Oh, not at all.
Yeah, I
got it. Mr. Nochumson did that.
I should have.
Back to order, having all members of the zoning board in front of us. Before this, before the application begins, I just want to announce that I am personally recusing myself from this application in this matter. So I'm going to hand the gavel over to the vice chair and I'll step down.
Okay, my name is Matt McCall, I'm the vice chair, so I'll be taking over at this point, and we will hand this over to our solicitor to get us started.
Thank you. This is Appeal 1195-23, the Borscht Belt Deli applicant and Mike Dallowitz, owner, appeal from an action of the zoning officer. The applicant owner appeal violation notice dated June 13, 2023, issued to Newtown Associates regarding an unpermitted electric neon sign, section 1104.B, installed without a building permit, section 1403.C. The subject property is located at 2124 South Eagle Road, Village Head, Newtown South, Newtown Township, Bucks County, PC, Planned Commercial Zoning District, tax map parcel number 29-10-85-5. I'm going to mark a few items for the record. We'll do this as zoning hearing board 1 will be, exhibit 1 will be the application packet, including the zoning officer memo and emails with the township. Zoning hearing board 2 will be a copy of the notice. Zoning hearing board 3 will be a copy of the posting and mailing. And zoning hearing board 4 will be the proof of publication. And let's just mark right now, the applicant handed up a book we marked as 1 through 6. Let's call that A1 through A6 for record keeping purposes. And when the township presents, we'll go with T for township. This is a appeal of an action of the zoning officer, and we will turn it over to the township solicitor.
Thank you, Mr. Solicitor, Vice Chairman, Board Member David Sander, representing Newtown Township in this case, in opposition to the appeal filed by the Borscht Belt, Mr. Dallowitz, against the enforcement notice issued by the zoning officer regarding the sign, about which I think everyone is familiar. There's a neon sign in the front window of the Borscht Belt Deli that, in the township's view, is illegal. The township took enforcement action against the applicant, and unfortunately for the applicant has not filed a timely appeal. The appeal was filed on August 21st 2023. The action appealed from in the application itself is a July 5th enforcement action taken by the zoning officer. Obviously, August 21st is more than 30 days after July 5th, and I will hand up to the solicitor for counsel a copy of section 914.1 of the MPC. 914.1B states that all appeals from determinations adverse to the landowner shall be filed by the landowner within 30 days after notice of the determination is issued. In this case, the notice that's being appealed, as I said, I asked the board to take judicial notice of the application itself. On page 3 of 6, it says, the action taken was 7/5, that's a date, 7/5, July 5th, responded and notified me of electronic window signs not permitted in Newtown. The date of the action was 7/5. That's the application that's before you, that's the four corners of that application. The appeal, if you look at the appeal itself, has a date stamp of August 21st, which is more than 30 days after that. I do have a case that I'll provide to counsel and hand to the solicitor. This is a case called Martin versus Zoning Hearing Board of West Vincent Township. And where I've tabbed it, as the solicitor notes, it holds that pursuant to section 914.1B of the Pennsylvania Municipalities Planning Code, all appeals from determinations adverse to the landowners shall be filed by the landowner within 30 days after notice of the determination is issued. This notice of determination was issued on July 5th. In that, the appeal was filed on August 21st, more than 30 days after the enforcement notice was issued. This appeal is untimely and must be dismissed. And I would put that in the form of a motion to the zoning hearing board for dismissal.
Thank you, Mr. Sander. Counsel, can you introduce yourself on the record first?
Oh, yes. Good evening. My name is Alan Nochumson of Nochumson, PC. I represent the appellant, Borscht Belt Deli. And to my left is Mike Balowitz from the Borscht Belt Deli.
Do you want to respond?
Yes. So in terms of counsel's legal argument about the timeliness of the appeal, we are the appellant, the tenant of the property. We were never officially notified directly about this notice of violation. If you look, all the violations were directed presumably to the property. But we, as the occupant of the deli, of the leased premises, were never directly notified by the township. So the clock never ticked on June 13th or July 26th or even August 15th. So there's no direct notice that we had to comply with in terms of the 30 days.
By way of rebuttal, Mr. Solicitor, if I may, Mr. Vice Chairman, that's false. The direct notice of the appeal taken from the July 5th went directly to Mike Dalowitz at mike@theborschtbelt.com email address. Mike, please note that the electronic window sign is not permitted per section 1104B of the JMZO and goes on from there. That is an email dated July 5th, 2023 from the Township Zoning Officer, Anna Gidhart, directly to Mr. Mike Dalowitz, sitting to Mr. Nochumson's left, advising him of the violation. It is from that enforcement notice that the appeal was taken. That is the only enforcement notice at issue in this case, and it went directly to Mr. Dalowitz. So it is false that the notice was given only to the owner of the property.
And Mr. Sander, for record purposes, the email you're referring to from July 5th is marked as Exhibit C to the memo from the zoning officer?
That's correct.
So that's a part of
That is correct.
that I previously marked.
May I respond?
Yes, and then I would suggest if the board could hold a brief exec session to discuss this motion.
So in terms of the notice requirements, this is an email. Again, Minister Sanders could like point to the record of where emails are considered proper notice here. Again, my understanding is that these notices were mailed to the property owner. That is the proper notice requirement within the township in terms of notifying individuals or businesses of any violations. This informal process that was then created by the township is not the proper notice mechanism for the township now to rely upon, not to hear the substantive merits of a case of selective enforcement. And that's what we want this board to understand. There are over 100 neon signs here in the township.
We're going well past argument on the.
Well, let me finish, and then I.
Talking about other signs in the
Well,
township.
I think Mr. Sanders doesn't want to actually have this board and the community hear about this selective enforcement, which is unconstitutional under the Pennsylvania and United States constitutions, which violates the due process clauses and equal protection clauses here. You know, we are personally outraged by how the township has conducted themselves in terms of doing selective enforcement based on the content of this sign. And if the board hears the history of behind the Borscht Belt and the deli, and the reason why we're so upset as a Jewish community, then I believe that this board will be outraged by this selective enforcement and have one choice or two choices. Either allow this signage to remain without any violations, or take down every single neon sign that's in the township, including a neon sign of a business that is nearby where the township has actually conducted business, paid money to a business which has a neon sign. So like
Ongoing objection.
Yeah, so
We're way beyond the scope of argument on the motion to dismiss this case because the email is a valid notice. It contains everything that an enforcement notice should be, and his client appealed from it. So he cannot now claim that it is not a proper.
There were communications. There was communications between Mr. Sander and my client where talking about false allegations, where you said that the reason why the signage was there's a violation is.
Can we get?
No, well, if he's going to attack my client's credibility, again,
I'm not attacking his client's credibility. I'm attacking his client's data which he filed his appeal.
The discussion that we're going to have regarding.
We're looking for the motion to dismiss, just the response in there.
Okay.
Is there anything else to add?
No.
Okay.
Okay, so we're going to take a brief executive session.